suit. And you're very
Good morning, Ms. Lewis.
Good morning. May it please the court. My name is Rebecca Rose, and I represent the appellant, Frederick Patton. Your Honors, in Mr. Patton's probation revocation hearing, the videotape of the sane interview of the 4-year-old little girl was not a reliable piece of evidence under any calculus. It was not reliable under the Commonwealth v. Durling standard for hearsay in probation revocation hearings. It was not reliable under general laws, Chapter 233, Section 81, or Section 82, the civil counterpart, nor was it reliable under a traditional competency analysis, because the trial judge never determined, as a baseline, never determined that this little girl was competent to make any statements. And the trial judge never determined that this little girl knew the difference between truth and fantasy or the implications of not telling the truth in any kind of proceeding. Therefore, accepting this and relying on this evidence was a violation of a basic right of due process.
Two questions. One, can't we infer from the judge's finding of reliability that the judge also found the witness to be competent or the girl to be competent?
No, I don't think so, Your Honor, because if you look at Durling, if you look at a basic competency analysis, or if you look at the statute, Section 81 or Section 82, the bottom line is there has to be some circumstance that support the veracity of the source, which is an underlying issue of competency. In Commonwealth v. Durling, the usage notes in the rules for the district court proceedings kind of enumerate all of the factors, and one of the factors is that the statements have to be provided under circumstances that support the veracity of the source.
And how old was she?
She was 4 years old. And in fact, there was no evidence at all that the judge considered any circumstances about this little girl. She had only the videotape to look at.
Well, I thought the judge found probative that there was a first complaint to the mother and that there was a report of that. I thought the judge found it probative that the parents immediately thought the girl's statement was reliable enough to call the police, and that indicated the parents' indication that the girl was credible. And then you also had the observation of the clear liquid on the child's vagina when she was being bathed. Isn't that all corroboration that the court may consider?
First of all, that was hearsay as well. There were no precipient witnesses to the event, and
That's not a condition precedent in a probation revocation hearing that you have precipient witnesses.
right, but reliability is.
But you did here have, in essence, a precipient witness. I think you had here much more than normal. You had the same interview videotape of the victim, the alleged victim, was introduced in evidence at the hearing. So the judge had the opportunity to see the victim being interviewed just as much as if it were in court.
Correct, but there's still the basic underlying issue of this 4-year-old girl, if she knows the difference between fantasy and truth, and if she knows the consequences of not telling the truth. And that's a bottom line, that seems to me, for any due process calculus, that's a bottom line guarantee, that the witness, there has to be some way to determine that the witness is true, knows the difference between truth and fiction. It doesn't usually come up.
With a little child who's 4 years old, isn't an interview at the time closer to the event much more likely to be true than something that's a year or 2 years later? I don't know how much later this.
Well, I don't know. There certainly wasn't any evidence at this particular hearing, and in fact, there was quite a bit of evidence that the little girl recanted. Again, it was all hearsay evidence, but the defendant does have a basic due process right to rebut the evidence against him as well. And when the trial judge admitted the mother's the statement, the piece of hearsay as a first complaint witness, again, that was first complaint evidence is not actually corroboration of the event; it's corroboration at trial that the declarant actually made the declaration. However, in this instance, I'm sorry, Your Honor, the mother's, when the judge admitted this as first complaint testimony, she said that, I'm admitting it, it's reliable because it would be first complaint testimony. She didn't say, I'm admitting it's reliable because it's detailed or factual, or I can support the veracity of the source, any of the factors. When she admitted it as being reliable, she admitted it as reliable because it would have been admissible at trial as first complaint evidence. And that's not the standard for hearsay in a probation revocation hearing.
Did you bring this as a motion for new trial? Is that how you, 30B? Is that how you?
Yes, yes. The trial attorney did not file a direct appeal. And by the time, and he did file a direct appeal of the motion to reconsider, but that motion was also untimely. So in order to vindicate Mr. Patton's right of direct appeal, we filed a Rule 30 motion below.
Why is that the route? Aren't there other routes? I mean, this really isn't a motion for a new trial, as we understand it.
Well, it was, essentially we were trying to vindicate his right to a direct appeal because his trial attorney didn't file that motion. And by the time I was appointed, the transcript was ordered, it had been a year from the time
certainly you could get a motion to file late up to a year.
Right, and it was beyond a year. So the
Doesn't that mean it's gone? I mean, you've got a year window here.
No, in fact, and I do cite the case law in my brief that if his right of appeal was frustrated, there has to be a route to be able to get that appeal if it's based on ineffective assistance of counsel. In this case, counsel didn't file an appeal even though his client asked him to do it, and asked him more than once to do it. And there are affidavits to support that. In the record appendix.
So the ineffective assistance is essentially the failure to file.
Correct, and which completely frustrated his right of appeal by the time appellate counsel was looking at it.
So there can be no cutoff to that.
And that's
Even a year, saying after a year, there's just no way this can be appealed.
Well, which is why, in fact, why I filed the Rule 30 motion, which can be filed at any time.
Mm-hmm.
Was there an affidavit from trial counsel?
Yes, and it is in the record appendix.
From probation revocation counsel. Right?
Correct.
Yes.
Not trial. In fact, there wasn't a trial. This ended up being null pros.
And what did trial counsel, what did probation revocation counsel?
I'm sorry?
What did probation revocation counsel say as to why he didn't think it was meritorious?
Correct. He didn't think there were any meritorious issues in the case. He didn't believe that there was a reason to file an appeal. And he does say that in his affidavit.
That's what I thought.
I'm sorry?
That is what my memory was.
Correct. Yes.
So we have, of course, hundreds, if not thousands, of probation revocation proceedings all the time in our courts. Mm-hmm. They're not all that complicated. Are you saying now they're not over because at any time under a 30B motion you can file a 30B motion saying there should have been an appeal? Very few are appealed. Now you've opened this new window at any point in time if you think you had ineffective assistance of counsel back then, but they didn't, because they didn't file an appeal, this is now a door open to you.
Indeed, that's exactly what I'm arguing, and I believe that this court, the case law from this court, supports that. If the right of appeal is frustrated entirely due to ineffective assistance of counsel, then the proper mechanism is a Rule 30 motion, and then an appeal of the Rule 30 motion. In fact, I believe the case law even suggests that we could come directly to the appeals court and request an appeal based on that. To me, it seemed the better procedural route to file a Rule 30 motion and get an appeal. And in fact, we got, with the answer that Judge Saber gave on the denial of the Rule 30 motion, very clearly she said she relied on that videotape, which brings me back to the original point of reliability of the testimony of this 4-year-old girl. I would also suggest, I would also like to make the point in the basic, a probationer in a due process revocation hearing does not have the full panoply of civil rights, and confrontation issues are not implicated. However, due process is, and the Commonwealth v. Durling, which is the case we all rely on, does balance the rights. And in a normal course of a probation revocation that's brought because of a criminal complaint, the balance is the probationer's conditional liberty interest against the state's heavy interest to punish and to rehabilitate and administrative efficiency. But here, this was a sex offense, and as you know, sex offense crimes come with much more kind of collateral reliability. There are much greater implications, and I would suggest that the calculus, the balance in a due process consideration when there is a sex offense, even in a probation revocation hearing, weighs a little bit more heavily on the probationer.
I missed that. Why is that?
Because there are quite a number of collateral consequences if one is convicted of a sex offense.
But he hasn't
But he
been,
wasn't.
he wasn't convicted.
Well, indeed, if this is the kind of evidence, a judge found by the preponderance of an evidence that he committed this crime. And if he ended up in front of the Sex Offender Registry Board in an administration hearing, if he ended up on trial for a 123A sexual dangerousness hearing, this would all be admissible evidence and put in the calculus. So his substantial privacy and liberty interests concerning the sex offense are also, I think, affected here, and I believe should be taken into the balance, into the calculus when we're looking at the a due process calculus, which is why I suggested that General Laws Chapter 233, Section 81, or Section 82, which is the civil counterpart and is exactly the same as Section 81, might be a better guide, especially if it's a sex offense and if a child of tender years is testifying as to sexual contact. The bottom line is there really was no discussion about this little girl and whether she knew truth from fantasy. There was arguably you can look at a videotape and see the circumstances and you can see the details. They did quiz her on under and over and if she understood things, but there was never any underlying bottom line reliance on a kind of a standard competency issue here. And I think it's implied in most hearsay. If somebody's making a statement to the police and the police report is entered into evidence, there's a basic implication that there's reliability there. That was an adult who was interviewed and making the statements under pains and penalties of perjury to the police officer. But we didn't have any of those assurances in this case. We had a 4-year-old little girl for which there was no other information about her, about whether or not she knew the difference between truth and fantasy. And I would argue that that's a bottom line competency issue that has to be addressed somewhere.
What deference do you say is due to the probation trial judge in making that determination here?
I think she has to make it. I mean, there's always a deference to the trial judge making a credibility assessment, but she didn't make it here.
But where nobody has asked for that determination to be made, and there's nothing in the judge's findings that really flag it as an issue. Can't we infer from the record that the judge implicitly made the finding that she was competent?
Well, if I may, in fact. In the hearing in February, in fact, I think she did not. I think she made it clear in both of her rulings that she relied on the information in the videotape and nothing else. And in fact, she implied at the hearing to reconsider her ruling. She does say that when she was making her when she was telling the trial attorney why she wasn't going to vacate the sentence or resentence him, she did say, now, if this goes further, she said, this is on page 26 of the transcript from February 29th of 2008. She said that, watching the video where the little girl made the revelations of the improper touching, she relied on that. She goes, now, if that is not a viable criminal case in the future because of, maybe she's not competent or she recanted, then there was a break. And she said, in viewing that, I feel warranted in viewing the video of making the decision that I made. I believe that that's an implication that she didn't make a competency analysis, in fact, that she didn't think she had to in a hearing. And my argument is due process requires that at a basic level, that the veracity of the source, even if it's hearsay, be confirmed in some way, which is why I suggest that General Laws Chapter 233, Section 81 or 82 be applicable as some basic guidelines, especially the part, not necessarily the first part of the statute, which deals with the confrontation issue and the unavailability, but the second part of the statute, which deals with a special guarantee of reliability. And there simply wasn't that in this case. This was a 4-year-old little girl who the judge just looked at it and said, well, I believe her. And I argue that that's not enough in the due process.
I'm still trying to sort out what the judge who writes this is supposed to do. I assume you want that judge to look at that videotape.
Correct. But I believe, and the reason that I believe that due process requires the judge to also somehow look at her competency, not necessarily bringing her in or making her available, but talking to someone else who knew the little girl. And in fact, even Section 83, which is which is a companion to Section 81 and Section 82, requires that the person who heard the statement come in and be able to testify as to the veracity and the details and the kind of conditions of the little girl.
So you're saying that as a matter of law, a judge, including us, could not look at that video and make a determination that this child witness was competent to testify?
I think this particular video, I don't think I could, I'm not arguing that as a matter of law that a videotape is not admissible and is not competent evidence. In this case, because the little girl was 4 years old, because she wondered, because she, it's a powerful piece of evidence, but it doesn't have that underlying guarantee of the veracity of this little girl, or that she knew the consequences of telling a lie. And that's a bottom line issue in competency. And I think it's assumed in hearsay cases but it can't be assumed for a child of tender years, especially a 4-year-old. And in this case, the judge relied almost exclusively on this piece. And I think it's very clear that this was the most important piece of evidence, and it was a powerful piece of evidence. But in this case, relying on it exclusively violated Mr. Patton's right of due process in this proceeding.
Thank you, Ms. Lewis.
Thank you.
Good morning, Ms. Spooner.
Good morning, Your Honors. May it please the Court. This Court has consistently held that reliable and substantially reliable hearsay.
Before we get into the merits, excuse me for cutting you off.
That's okay.
Could we just deal with some procedures here?
Sure.
What you have is a probation revocation hearing, not a trial, okay? And you have the failure of the counsel to take the normal route for an appeal from that decision.
Correct.
Right? What do you think is the best way to deal with what is in essence an ineffective assistance of counsel claim?
While the Commonwealth may not have a position in all instances, I do think that the defendant did have a right to contest the effective assistance of counsel.
But we have to tell people, because there's been some confusion, I don't think the Supreme Judicial Court has spoken on this.
They
correct?
have not. You have not.
And the Appeals Court has been doing its best, correct?
Correct.
So it would be helpful to counsel and to the Commonwealth and to everybody else if we told them what to do.
I do think that the defendant does have to have some recourse when there is an ineffective assistance, and Rule 30B would be the appropriate course of action in this case, and in fact that is what happened.
And then what do? Do we limit that to whether there's an ineffective assistance of counsel claim, and require a specific ruling on that can then be appealed by the Commonwealth?
I do think in this case the ineffective assistance of counsel claim was the only thing that could have been issued. I'm not saying in all of the cases that's the only way a Rule 30 motion would have been able to be allowed. There are specific instances through a regular course of a criminal trial when Rule 30 motions are allowed, such as newly discovered evidence and other things, which I do not think should apply to a probation.
No, I'm just kind of limited to probation revocation hearings, right? Let's assume, for example, that are we talking about any circumstances other than a failure to take an appeal? Are we talking about a late appeal? I'm really looking for the Commonwealth's guidance of how best to handle the probation revocation hearings where there hasn't been any proceeding beyond the initial hearing and the decision of the probation revocation judge.
I do think because in this instance the probation revocation attorney did eventually file a motion to reconsider. It was untimely. The court did recognize it, did rule on it. So I think in that case, because he did take steps, that the ineffective assistance claim is now valid because he untimely did attempt to clear the court's decision on what had occurred prior or subsequent to the probation hearing. So I do think in claims of ineffective assistance when the trial or the revocation attorney has not done anything, that this court should allow a Rule 30 motion based on a claim of ineffective assistance.
So this case is properly before us under a denial of a Rule 30B motion?
I do think that this court can properly hear the motion. The defendant would otherwise have no recourse if his counsel was ineffective for failing to file any type of appeal to the probation revocation hearing.
So to the extent you argue otherwise in your brief, we should disregard that.
Well, I think that he does have only two means of appeal of a revocation hearing in general. In this case, he couldn't just appeal the revocation hearing now by saying, I'm going to file this motion now, even though it's late. But he does say, my counsel at the time should have filed it. I asked him to file it. He doesn't. Now I'm filing a claim of ineffective assistance. So in the normal courses of appeal, no, this wouldn't be properly before this court. But as a claim of ineffective assistance, I do think it is. But I think if the court views it under an ineffective assistance counsel standard, they'll reach the same conclusion, that whether or not counsel was ineffective, which I don't think that he was, the second prong of Safarian is still not met. And the defendant was not deprived of a substantial defense at the revocation hearing.
And now I assume with regard to that second prong, the key issue is whether or not he would have prevailed on appeal had he brought it timely.
Correct.
And as to that, the core issue is going to be whether or not there was sufficient reliable evidence on which to make the finding.
Correct.
And what deference do you say is due to the trial court judge in this particular instance with regard to that?
Well, typically in cases where there's demonstrative evidence, this is a videotape, this court is in a position to review all of that evidence de novo and take their own opinion of what they think the reliability of the evidence is. I think that it's important to take into consideration the judge's findings of fact, because there also was 2 live witness testimony that went to the videotape, that went to several police reports, and went to subsequent investigations. So in terms of the judge's findings, it is important to take a look at them and provide them with some deference.
Let me ask you this. In a non-probation revocation hearing, when we have a 4-year-old, there typically has to be a determination that the 4-year-old is competent.
Correct.
Correct? So the 4-year-old in the probation in this case tells her mother something. Her mother is not dissembling. Her mother is saying what the 4-year-old told her. But if we haven't had a preliminary determination somewhere along the line, in other words, as I understand the testimony, and I haven't read the whole transcript, the mother is repeating, or whoever is repeating in police reports, what the 4-year-old said. As I understand the defendant's argument here, there's been no preliminary determination that anything she said in any circumstance to her mother, to the sane interviewer, was competent, wasn't fantasy. Help me get past that.
That is correct. The judge made no specific finding as to the child's competency, but I think that it is implied in her reliability and in her
But
focus.
how can it be implied if nobody has asked the mother or asked the police officer, what was your basis for concluding that your child, wasn't fantasizing?
In viewing the videotape and in reading the transcript, the judge was able to observe the child's demeanor and observe her answers to certain questions.
You can't have that you normally have to have a finding of competence. Children fantasize.
I do agree that in typical situations, the judges hold separate hearings. They have specific meetings with the child.
It could have been examination of the mother. It could have been examination of the sane interviewer.
It could have. The mother was not present at any of the hearings, and the defendant made no indication that the mother would ever be present at any type of hearing for the judge to be able to question her. So I think that the judge relied on the evidence that he had. It was somewhat of an undue burden to require the Commonwealth and require the judge to hold separate hearings.
If you go back to Durling, you have to have reliable evidence. And so if you want to introduce evidence, you have to have some basis for saying it's reliable. And I'm asking you to tell me, not just saying, look at it, you'll see. Where do we know? Point me to the evidence that will tell us, reviewing it, that this child is not fantasizing.
The only evidence that the judge had to make that determination was the sane interview, the reports from the police detective who had been present at the sane interview, had questioned both the father and the mother, and then the mother's statements to the police herself, which was admitted as first complaint witness testimony. And I think that the court did have all of these things on which she could make that determination, and that's all that she had to make that determination. At no time the mother present or the SANE interviewer. The detective did testify at trial, and she did have the ability to testify as to what took place at the SANE interview. But at a probation revocation hearing, I do think that that is enough for the judge to rely on to make these determinations.
Now, your sister pointed us to page 26 of the transcript of February 29th, 2008. She read us a section. It sounded like the judge was saying that in the future there might be some ruling on competency.
I do think the
Which
standards...
suggests it's not implicit that the judge was making a competency finding at that point in time.
I think what can be inferred through that is the standards at a probation revocation hearing are much less than at a criminal trial.
We know that.
And I
They
think...
include, there has to be reliable hearsay evidence.
I agree, Your Honor, but I think what is deemed to make the evidence reliable is different, and the standards are different at a probation hearing, and I think that what the judge did have in this case was enough for her to do that.
But
What
you
she
haven't,
was
if you
saying...
get- maybe you're not here. I'm trying to ask the question 9 times. I'm really asking for help, and you're going back and repeating the same thing over and over. So let me. Is there anything, if we look at the police reports, the mother statements, anything else? Forget that they're hearsay. I don't mind that they are hearsay. That will say to me, this child, this 4-year-old, is competent because I've interviewed other 4-year-olds. I asked her certain questions that indicated that she, whatever it is there anything? Don't tell me just to go look at it. Please don't tell me just to go look at it all.
The evidence in this case during the SANE interview, which was admitted, does have preliminary questions that goes to the child's awareness, her knowledge as a 4-year-old, what parts of the body are which, and I think that is one factor that goes towards the child's competence. I also do think that the corroboration of the child's statement, although it did come from other witnesses, the story was consistent. And I think that the consistency of the child's story also does go to her competency, as well as the SANE interviewer, who is a trained forensic psychologist. She knows what types of questions to ask the child to determine whether or not the child itself is telling the truth. And I think those two factors, specifically in this case, do tend to show the child's competency, and the judge properly relied on those things. I think...
Given the judge's conclusion here, isn't it implicit that she found the child competent? If she didn't find the child competent, she wouldn't have revoked the probation. And then isn't the question for us whether there is evidence in the record that supports her finding, or whether she's clearly wrong?
I do think that implicit in her terminology is she finds the video substantially reliable, and I do think that implicit in that is that she found that this 4-year-old was competent. Otherwise, you are correct, she would likely not have taken such heavy weight of the video, and would have then said, oh, well, now this child made up another story and takes it back, or now she recants it and we have that evidence from the mother. Because she relied on this video, I think that implicit in that is the judge's finding that the child was competent, and she took that not only just from the video. I think she could take that from the remainder of the evidence that was presented at the hearing. I think the defendant's position that Section 233, Chapter 233, Section 81 should be admissible in probation hearings is also not something this court should allow. The standards, again, at the two hearings are completely different, and the burden that Section 81 puts on the Commonwealth is an unfair burden when you balance the interests of the defendant and the Commonwealth. The defendant has already been convicted of a crime. By the grace of the court and the court's discretion, he was put on probation. The cost and everything to the Commonwealth to now virtually have to retry him for this offense, as opposed to following the standard and the normal procedure of a revocation hearing, would be an undue burden on the Commonwealth if that statute was to apply to revocation hearings.
Now, in Durling, we said not only that there must be reliable testimony, but that when hearsay is offered as the only evidence of the alleged violation, the indicia of reliability must be substantial. Is this a case in which we should apply that standard?
I think so, Your Honor. In this case, although this was not the only piece of hearsay evidence, there was several pieces. It was all hearsay, and the video in this case was substantially reliable. This court has held that videotapes are inherently have special characteristics that make them more reliable. They're pretty much as close as you'll get to live testimony, which in itself does have.
It doesn't go to competence.
It doesn't go to competence, Your Honor, but it does go to the reliability of the evidence.
It's not reliability in that sense. It's the competence. It's not whether or not this child said this.
I agree, Your Honor, but in response to Justice Gant's question, I think that the substantially reliable standard in Durling is what was applicable to this case, and I think that the court properly found that it was substantially reliable. I think she was able to base her reliability on, with the inclusion of all of the evidence. She had several police reports, the mother's statement, and even the evidence that was admitted by the defendant to now contradict the child's statement was inherently contradictory in itself. You had different testimony, a statement from the father as to why the child recanted, and a different statement from the mother. And I think with all of those together, she could properly rely on all of the evidence as substantially reliable.
My question is a bit different. It seems that in Durling we speak about one standard with regard to the admissibility of the evidence, and then a higher standard if that evidence is the only evidence. Do you think that higher standard should apply in this case?
I do, because all of the evidence, principally that the judge did rely on, was hearsay. So in order for her to rely solely on hearsay to make the determination, it must be substantially reliable. The judge also, in Durling, the court also does rely on this good cause exception to hearsay, and the judge also did make those findings in this case. So she did properly apply both to the standards in Durling, and she did find that there was good cause, again, for not having the child witness at the hearing, as well as also why the mother and the father were not present at the hearing.
Thank you, Ms. Berman.
Thank you.